Good afternoon. So this is the second class of Foreign Legal Materials 1 on the International Human Rights System. So I did a little research and I found a new system to do recording that's going to allow me to go through the slides in the video, and hopefully this will make it a lot more interesting for you to follow along. So I know sometimes a few extra students may join in the second class, and also it's good just to review the course. So let me go back over a few things about the class. So for each class, you can go to the you can go to the learning management site on the Hopi, and there you can find materials for every class. You'll find these slides, and also for many classes I'm going to start giving a text, and this is the text that we're going to have for this class. I've already put it up on the system. An overview of the framework, and you can see it has text describing the International Human Rights Framework, and it'll go into detail about all the different human rights bodies at the different levels, at the regional and international level, and has some nice charts to help you understand. And it's only about 5 pages, so it's relatively short. And then these slides, also. Also, there's the fundamentals page. This is an overview of all of international human rights law, and a lot of what we're gonna, this at the bottom is a lot of what we talked about last time, the 3 different parties and the 3 different kinds of duties to respect, protect, and fulfill. And the second page is a lot of what we're going to cover today, the international bodies for human rights. So if you just want an overview of all the basics of human rights, and you can see here's this list of basic human rights duties. I said one thing a little misleadingly last time, that customary international law is only the most important obligations. Customary international law includes most of the customary international law, remember, is human rights that aren't written down, but states still follow them because the states explicitly acknowledge that they're legal obligations. And so most of the rights, almost all of the rights in this list, these bullet points, are considered customary international law. So even if a state didn't join these treaties, they would still be obligated to these bullet point rights, because they're considered customary international law. All right. But sometimes the customary international law doesn't go into the same detail that you get in laws that are created by treaties, where the standards actually written down, so they're more detailed. And so that's that. Let me just go over, here's the syllabus. So you can see it's 12 courses instead of the normal 14. And you can see these first 2 classes are more introductory. Then we'll do civil and political rights, economic, social, and cultural rights. And then you can see 4 classes, women's rights, trafficking, LGBT rights, and disability rights, and children's rights. This is what I would consider the courses for vulnerable populations, but we're also going to be looking at core rights like the right to privacy, right to health, right to family and education, along with each of these. And then these next 2 rights are core civil and political rights. We have fair trial and penal rights. Penal means rights involved with criminal law, and then freedom of expression, assembly, and association. And then we have this last class on kind of new developments in human rights with civil society, internet, and human rights. So as far as the course grades go, is what's expected of the students. So in a normal class, we would have class discussion. Since we're not meeting in person while we're doing classes online, I may put some discussion questions on the learning management site. For the class, there's a forum option that you can see where that will have discussions, and I may put up discussion questions that you can respond to. So it's a kind of awkward way to have discussion, and it may not be clear always what you should say in these. Try to respond to some of them as you see them. What I'm thinking I might do this is have the core of the grade be these case notes at the bottom, and then what I think discussion might be is a kind of, it will boost your grade if you participate in discussions. And if you worry about the grades on your case notes and you want to boost your grade a little, then try to participate in some of the discussions. But if you don't participate, or you don't have to worry, this isn't an English class, first of all, so you don't have to worry about your use of English. It's more just getting across the ideas. And the discussion part isn't about always getting the right answer. It's just engaging in the discussion. And I think it's something if you're not engaged very well, I don't know if it'll hurt you too much, but it'll boost your grade if you join in some of the discussions. So for the class, for the grade, the main the main assignment that you'll have is a case note. Actually, 2 case notes, a practice one and then the final case note. So I used to just only have a final case note, and I realized students weren't really understanding how to write a good case note. So I decided to add a practice one so that you have a chance so you can turn in the practice one and I can give you notes about how to improve and write a good case note. And that will help you a lot. So the way I'm going to structure it is the practice one will be graded just basically based on participation. And we'll also have a session, and you can see it here on the syllabus where it says writing practice. So part of this class I'm going to set aside and tell you how to write a case note. And the first case note, actually, I'll give you instructions. You're going to write it, but I'm going to tell you how to write it. So you're basically just going to be following instructions. And if you just listen carefully to what I say and just follow it like that, then you should be able to write your own case note just based on what I say. So I'm going to tell you how to write it. And then you're going to turn it in to me. And that's, so this would be June 30th when I assign it, and we'll go over it, and then June 10th is when it would be due. That's about 10 days later. So that's the due date for the practice case note. Turn that into me, and I will give comments about how you can improve it. And basically you get graded just by following the instructions and participating and turning it in. So don't worry about too much about the content, just try your best, and I'll give you comments about how to improve it. And then you can use those comments for the final case note, and I'll assign the final case note. I'll probably send it out around this July 7th, and that'll be due 2 weeks later. July 21st is the due date for the final case note. So for this final case note, you're actually being graded on the content itself. Also due by 6 p.m. So, and also this July 21st, this is exactly 1 week after the last class, so it's on the Tuesday. So you're going to be graded on the content of the case note. A case note is like if you were the lawyer or judge arguing a case, basically. It's like a kind of legal brief where I give you a fact pattern, a situation. I'll tell you a little story, and in the case note you say this is the human right issue that's involved. These are the standards how to judge whether the human right was violated or not, and then you look at the facts of the case, and then you do a little analysis saying, I actually think a human rights was violated here because of X, Y, and Z, or I think actually the human right wasn't violated in here. The state had a good reason, to restrict it, or whatever the analysis is. So you're going to use the exact same analysis that every class is basically going to go through the analysis of how to apply the law to certain cases. And so you're going to be applying exactly what we're going to be talking about in class, and I'll tell you more about that. Okay, so that's the case notes, and that's the syllabus, and if you have any questions, you can always email me. you can always email me. My email is on the learning management site. I've written it there, and it's also, you can see it here on every slideshow. On every slide I always have my email written. Or you can put it in the discussion if you think it's the kind of question that other students might also want to know about, or you want to have a discussion about it. You can also ask me on the discussion for any class as well. All right, so let's get to the class. So last week we were looking at, we spent a lot of time just focusing on what are human rights. And our basic answer was that human rights are legal standards. Human rights, first of all, are laws. They give you a legal standard, a set of elements that you know when an actor does a certain behavior, takes some action, or refrains from, or doesn't take action that they're supposed to, you match it against the standards that the legal duties give you, and that will tell you whether the human rights was violated or not. In international human rights law, these legal standards have sources, and we talked about the two major sources. Treaty law, which is treaties are a kind of contract, a document that states sign, and then they adopt it as part of their domestic law, so that makes it a legal duty inside the state. And once it's written down and becomes a legal duty, that makes an obligation. And then we said the other category is unwritten human rights, which we call customary international law. And some of you may have a question: how do you know if human right has developed into customary international law? And the answer to that is, well, first of all, remember, there's always duty holders and right holders. So the main duty holder, the main party that has the obligation to follow human rights law is typically the state actors, government actors. Because this is international law. In international law, the parties, the legal claims and the parties that have the obligations are typically states. States are the ones that sign treaties. Private parties don't sign treaties. So the state has the duty usually, if there's a human rights violation, the violation is usually by the state itself. If a private person violates a human right, that private person is not a party under the treaty, under international law. It's the state that they live on that's the party to the treaty. So we say even if a private person violates a human right, it's the state that's violated the right. And you may ask yourself, what did the state do that has to do with this human rights violation? And the answer is the state didn't stop private people from violating this human right. So an easy case is the right to life. If you have a vigilante group, some terrorist group, or some, whatever group it is that's killing people, and we can see an example of that in the Philippines. If the police don't do an investigation and they allow these murders to happen, now that has become a human rights violation by the state. And we see this, for example, in historically in a country like Cambodia. There were communists in the countryside, and the police were finding it difficult to fight them, so they started using these vigilante groups, these private like little terrorist military groups that were fighting the communists, and the police were helping them. So they were doing murders, and the police weren't prosecuting these murders or stopping them. This is happening these days in the Philippines with Duterte. He has a war on drugs. There's a lot of killing by the police themselves, but a lot of the killing actually happens by these outside military groups, but the police don't do investigations. So this makes it a violation. This is how the state can violate human rights, even if it's a private party that's doing that's actually committing the violation. And then we talked about the categories of duties. So when states have to stop their own actors from violating it, we call that a duty to respect human rights. So many human rights are violated by what we call security forces, so like the military and police. If you have a military police that are torturing people because they want information, the state needs to stop its own actors doing that behavior. That's called a duty to respect. Now, when we talk about private people violating, the state has a duty to stop the private people from violating rights. We call that the duty to protect rights. So duty to respect is the state stops itself violating a right. The duty to protect is the state has to stop private people from violating the right. And the duty to protect, actually, it doesn't even have it. The duty to protect is you have to protect people's human rights from any, the state has to protect people's human rights coming from any source, not only private people. So when we speak about the right to life, you can imagine other threats to life. So something like a disease, or something like a natural disaster, like a typhoon. Those can kill people. The state has a duty to actually protect life for those. That's under the duty to protect, even though they're not even private people. They're, they come from nature. And then we have the duty to fulfill. Sometimes the state has to take proactive action. So that's basically a summary of what we talked about last time. So in this class, we're going to be talking about the international human rights system. So if you remember, in one part, last time, I mentioned the three parties that are involved in human rights. You have the rights holders, you have the duty holders, and then you have a party in between them. When there's a dispute, or when there's an allege of a human rights violation, you need some body in the middle that decides whether a violation has occurred and enforces the law or has some legal consequence come out of it. In domestic law, this would be something like a court, the police in the court. If someone's committed a crime, the police will investigate, and it will go to a court, and a court will stand between the two sides of the case, the one that violated a right and the person that claims the right. So the person that claims the right is the right holder. We said that's typically all the population inside a territory. For these two core treaties that we mentioned, the ICCPR and IESCR, these core human rights treaties, the rights holders is everyone in the territory. So the government of Japan, as a member of these treaties, has a duty to protect these rights for all of the people inside the territory of Japan, including foreigners and citizens. And then the duty holder, like I said, is typically the government itself. Sometimes actually non-government actors can also be duty holders directly under international law, some international businesses, corporations, some non-state military groups like rebel groups, but very often it's the state. And I said there needs to be some party in the middle. So sometimes this can be the state itself. The state sometimes has its own court system. So if a police officer, military violates a human right, there can be a domestic process to adjudicate that, to resolve that human rights problem. But another source, there are international sources. There are international bodies that can also serve that institutional role between the rights holder and the duty holder. So if the military or police or some other government actor violates a right and you have some victim that was the rights holder, you can have international bodies that mediate between the two, that may do an investigation and decide, yes, there was a violation here and maybe some legal consequence should follow. So this is what we're going to talk about today. We're going to be talking about these bodies that serve this institutional role to actually enforce and implement human rights law. So one important, one core, let me make this, resize this a little, principle of international law. All right. So the international human rights system. Let's just start with the history of where these bodies come from. So in the last class, we mentioned treaty law, that a lot of human rights have sources that come out of treaties. This is when states adopt treaties like contracts. But a lot of the human rights comes under the United Nations system. So what we're going to be talking about is for the human rights system is going to be at the center is the United Nations system. So all of the human rights treaties are under the umbrella of a United Nations system. And of course, that was founded in the post-war 1945 for state cooperation to avoid wars and human rights abuses. It was built on respecting human rights. So at the center, one thing to note about the human rights system is that at the center of it, it also has a treaty, which is called the UN Charter. So the UN Charter that creates the United Nations is itself a treaty. And you can see two articles under the UN Charter. One, Article 1.3 of its purposes says one of the major purposes of the United Nations is to promote human rights. And then under Article 55c, the UN shall promote universal respect for human rights. So from the very beginning, the United Nations was given the mandate to promote and respect human rights. Okay. So when we talk about international bodies, we talk about we talk about them in terms of their legal status. So we said international law has to come from sources. And we mentioned the two sources, treaty law and customary international law. When we're talking about institutions, the institutions also have to have a legal source. And for institutions like the United Nations and some of these human rights bodies we're going to talk about today, these all need to be created by treaty. You can't create an institution by customary international law. You have to create them by a treaty. And then so we just said the United Nations was created by the UN Charter. So if you wanted to know what powers it has, the UN Charter is what tells you that. So under the UN Charter, it creates two bodies that are very involved in human rights issues. And these are called charter bodies because they're actually created by they're created by the UN Charter. Okay, so these are the two bodies. We have the General Assembly and we have the Security Council. The General Assembly is a group of states that adopt resolutions, and many of the resolutions are on human rights topics. So General Assembly resolutions can be very influential, but they're non-binding. Non-binding means they don't have a legal status. They don't have a legal binding status. By binding, I mean you have a legal obligation to follow it, and it's a violation if you don't follow it. So General Assembly resolutions aren't binding, but they're very persuasive. And last class, we talked about the difference between hard law that's binding and soft law that's developing into binding law. So one role of the General Assembly is this is the group of states when they vote. Very often when we talk about the soft law sources like recommendations, declarations, guidelines that offer guidance that are developing into hard law, but are still, there's just standards of best practices, what states should do, but they haven't developed into hard law yet. These very often come from General Assembly resolutions. That's the source of where a lot of these declarations and guidelines for state behavior come from. And when many states pass them in a General Assembly, that gives them an authoritative status. So I said this soft law, like these principles and guidelines, have a kind of quasi-legal status. It's not a human rights legal violation if you don't follow them, but it's still a legal problem. It's not just advice to give. They have a quasi-legal status, and states may be violating a developing customary standard when they do that. So the General Assembly plays a key role in developing these standards to eventually become human rights hard obligations later. So many of these standards that the General Assembly pass, over time, eventually they'll become a treaty and become hard international law. So that's how the General Assembly works to help create standards and give them an authoritative status to develop them towards international, human rights legal duties. Then we have the Security Council. So the Security Council is also a group of states. It's a smaller group that has 5 permanent members: China, the UK, America, France, and Russia. So, and then maybe about 20 or 30 other members. You can see them all sitting around the table here. So they also pass resolutions. They vote and pass on resolutions. And many of their decisions have to do with intervening in states for peace. So when there's a conflict situation, like when Saddam Hussein invaded Iraq or invaded Kuwait. The Security Council passed a resolution to have intervention that started the Gulf War, and states participated and cooperated in that. And since the 1990s, the Security Council has also done other forms of intervention, not only military intervention, but for example, when Yugoslavia broke into different parts and had the Yugoslavia Civil War, and it broke into Kosovo and Serbia and Montenegro and these other countries, the Security Council actually passed a resolution to administer Kosovo. Kosovo didn't have its own government. It was actually governed by a body created by the Security Council. It was governed by an international kind of government, a UN-created government, and the Security Council created something like that. And then, after the war in Iraq, after wars, sometimes the United Nations will come in and set up a kind of set of institutions to help transition the government into a new democracy. The Security Council is the one that sets those things up. The difference between the General Assembly is when the Security Council passes a resolution, it's legally binding. A state has to follow these rules, and they're binding. Okay, I forgot to put up this text. All right. Okay. And then with regards to human rights, so of course, when the Security Council is setting up institutions to help governments transition after a war or something like that, very often they'll help the government, they'll be involved in addressing human rights violations in that country. Especially after wartime, there can be massive human rights violations. And one special role the Security Council plays is they can refer a case to the International Criminal Court. The ICC stands for the International Criminal Court. So if there's been massive human rights violations and that country's not a member of the International Criminal Court's treaty, so the International Criminal Court can't take cases unless someone's a member of that treaty, except in one case, and that's if the Security Council passes a resolution to refer this human rights violation to that international court. It's legally binding. The person has to go before the court. So that's what the power that the Security Council has. Okay. So these are the two charter bodies, the General Assembly and the Security Council. Now we have other human rights bodies. So these were created in the 1990s after the Cold War ended. The international system for human rights didn't really work like it was supposed to until the 1990s. Because of the Cold War, you had these two, you had the liberal side and the communist side, these two factions, and they couldn't agree on cooperation for addressing human rights issues. In the 1990s, after the end of the Cold War, now there's international cooperation, and very quickly, in the 1990s, they created these in the early 2000s, they created these two bodies. So these are not in the charter, so they're not created by the charter, but they're under the umbrella of the United Nations power. And they're kind of mirror images of each other. So here are the two bodies, the Human Rights Council and the Office of the High Commission of Human Rights. So the Human Rights Council, like the General Assembly and Security Council, is state representatives. It's a body of states that come together, and they also pass resolutions. And it's powerful because when you have states voting on resolutions, that gives it a strong political power. There's a lot of politics involved. So international law is a little different than domestic law. In domestic law, politics isn't really involved. If someone, commits a crime, they do a robbery, the police will investigate it and that person will go to prison. There isn't really politics involved in that. It's all law. But in international law, if someone commits a massive human rights violation during a war, and that state itself is not prosecuting their own military, for example, it's up to other states and the international community to deal with this. And of course, intervention from one state into another state is a very political thing. If you want to put the people of another state on trial in a court, that's very political. So a lot of international law is also wrapped up in this bigger politics of international relations. So that's one thing that's important about the Human Rights Council is when you have a lot of states voting on a resolution on a human rights issue, that creates a lot of diplomatic pressure, because what those votes for the resolution means is those states agree with this, that this is an important human rights issue, and often those states will take actions from that resolution. So, for example, a lot of states might agree to pass sanctions, economic sanctions, to punish or to help pressure a state to follow human rights obligations. So that's the power the Human Rights Council has, is when they pass a resolution, it's state governments that are voting and passing these resolutions, and these representatives will go back to their home governments and have their governments follow these resolutions. So that gives them a lot of political power. Now you can ask yourself, is there any downside to the Human Rights Council? And the same plus side is also the same downside, which is the Human Rights Council is also very political. So the Human Rights Council being political is a good thing when it makes states create a lot of diplomatic pressure on other states to follow human rights bodies. But on the flip side, the Human Rights Councils is also can be political in the other direction, where they don't really want to punish a state. So you can have, a state that, nobody wants to go to war with, or, there's a state with some economic power, and states might not want to create too much diplomatic pressure because it might create a problem in international relations between the two states. So politics can get involved. And of course, international human rights law, there's supposed to be legal issues. Legal issues aren't supposed to be political, but in the real world, politics becomes involved, and sometimes states don't press human rights problems as forcefully as they could because of the diplomatic issues involved. So, just in the Asia region, I studied Myanmar as a country I've studied a lot, and of course, the military in Myanmar has been alleged to commit terrible human rights violations against some of its population. And under its constitution, it's immune from being prosecuted inside Myanmar. So this puts pressure on other states to try to stop these violations, but sometimes it can get really political. Myanmar is also an emerging democracy. In some states, a state like Japan would like to have another democracy in the Asia region. So, and also there's a lot of economic trade. It's opening up very rapidly. So the businesses coming in, are expanding. There's a lot of trade and economics involved. Some countries might be not pressing the human rights problems as forcefully as they should because of the international relations and the economics and the diplomatic issues involved. Okay, so that's the Human Rights Council. Beside that, we have the Office of the High Commission on Human Rights. So this is made up of this is the United Nations' own body. So the United Nations has an office for human rights issues itself. So for example, any human rights issue that happens inside the United Nations, so if you have some human rights violations occurring in a United Nations office, the Office of the High Commission itself is going to investigate that. It's made up of experts, but they also write recommendations, and they'll also write, the High Commissioner, the position of the High Commissioner themselves can write a lot of reports on human rights issues that has a lot of authoritative power. So it has authority under the umbrella of the United Nations system, but it's not as political. But at the same time, it can't obligate a state. It can't pressure a state in the same way the Human Rights Council can. So you can see how these are kind of two flip sides. The OHCHR, this office also regulates a lot of the treaty bodies that we're going to talk about later. Okay. So the Human Rights Council, this is a picture of, I just explained it before, but here's the state representatives. It meets 3 times a year in Geneva. It promotes human rights treaties, addresses and stops violations. If there's a human rights emergency somewhere in the world, it will respond to them. It's a forum for these states to discuss and pass resolutions. And then they review state compliance, and they conduct universal periodical review. So one of the roles of the Human Rights Council is monitoring different states' adherence to human rights obligations. And one major way this is done is through the Universal Periodical Review. This is a 4-year cycle. So basically, every 4 years, there's about 200 states in the world. You can divide them into groups of about 50 states. So there's 4 different groups. So every year, about 47 states, 48 states it says here. So every year, 48 states are reviewed on all their human rights obligations. So what that means is the state has to, Japan's was 2 years ago, I think, 2 or 3, 2017, I think, was Japan's year. So in that year, the Japanese government had to send a report about how they're complying with all their human rights duties, and then some of the challenges they have, and then their future work they want to do to help them, follow more the obligations. And then this group of 47 states, then there's a working group of other states that will comment on Japan's documentation on its report, and they'll give comments and say, I think you need to improve a little more on this. So you can see also how that's very political. It's a very political thing for one state to accuse another state of human rights problems, but that creates a kind of pressure because it comes from other states. And you can understand the government writes its own report about its own record, and you can understand how a government, when it reports on its own record, is it's going to give a very optimistic view. So Japan's not going to be too hard on itself. So it's up to other states commenting to say, did you think about this? But at the same time, while this review is happening, civil society, so NGOs and other activists out there, are also submitting reports on the record of a state's human rights obligations, and they're going to be much more critical, and they're going to find more violations. So we call these shadow reports, and these also are very influential. They don't have a legal status, but they're very influential. So anyway, the state submits its Universal Periodical Review report. It reports on how it's meeting its obligations. And then this committee of this HRC group will put together an action plan that they'll put together a plan about how this country, like Japan, can meet its obligations better. And they will have a follow-up duties. So they'll say, they'll give them a set of questions, for example, and say, in the next year, can you send us a follow-up report about how you've made progress on these issues, and here are recommendations. And then you can see that's how it's like a 4-year process. The state first submits its report, then there's a follow-up comments on it, and then a kind of schedule of different follow-ups. So there's a back and forth between the state and then the UPR system, the HRC, to follow up, and then the whole cycle is supposed to take 4 years, and then it starts over. Okay, so that's the UPR system. It's a way of monitoring. This is one way that human rights are enforced. We'll have a whole class on enforcement of human rights and accountability, but the one thing you can know right now that you can probably already start to tell is there's not an international police department. If someone violates, there are international courts like the International Criminal Court that can try cases and people can be arrested, but for most human rights, this kind of monitoring and report writing is the way that human rights are implemented. States have to write reports about their meeting their obligations, and there can be fact-finding missions and investigations, and there's a lot of report writing. So it's a very administrative thing. So human rights, most of international human rights law is very administrative. It's about reports and follow-up reports. Okay. And speaking of reports, so under the Human Rights Council, we have experts on certain human rights issues, and their main job is to write reports on specific human rights issues. They'll write issues about it generally, but also they can actually do state visits and write about human rights issues in a particular country. So this picture right here is David Kaye. He's the Special Rapporteur for the freedom of expression. He did a visit to Japan, I think in 2018, and he wrote a report about Japan's shortcomings in meeting the freedom of expression, and he gave recommendations to Japan about how it can meet its obligations. So these special rapporteurs are also called special procedures because they're created by a resolution for just a short term, and their term has to be renewed. So because they're not a standing body. It's just a position that's held for a certain time and renewed. So that's why they're called a special procedure. And all of these bodies created by the Human Rights Council are called mandates. Mandates just means something created by a body or a position created by a Human Rights Council resolution. And we can see special rapporteurs have issue mandates. So there's a special rapporteur for torture, for sale of children, for health, for the right to housing. And then special rapporteurs are also for states. So there's a special rapporteur that only deals with human rights issues in Myanmar. There's a special rapporteur that deals with only human rights issues in Iran and North Korea. And they'll write reports on their topics. These are two other bodies. We have fact-finding missions. So a Human Rights Council resolution can create an investigation team that will actually do an investigation on a specific human rights issue, and then they'll make a report and give recommendations. In the case of Myanmar, there was a fact-finding mission created for Myanmar, and the Myanmar government actually didn't allow them, because of the politics were so sensitive, they actually didn't allow the mission to enter Myanmar, so they had to do their investigation outside. But they still did this investigation, and they had recommendations, and then there's a lot of politics involved about whether the state wants to accept the recommendations. That also happens in the UPR cycle too. When Japan had its UPR cycle and a lot of states gave comments and recommendations, Japan accepted some recommendations and noted some recommendations, and some it just stayed silent about. Okay, and then we also have working groups. So we have special rapporteurs or individual experts, but sometimes there's a group of experts that work on an issue, and these are called working groups. In the Human Rights Council, there's, for example, a working group on business and human rights that just talks about this issue. Okay, and then in OHCHR, like I said, the main central position is the High Commissioner of Human Rights. The current High Commissioner is Michelle Bachelet. It's based in Geneva. She's the boss. They promote human rights in the UN system, but they'll also do investigations, reports, and recommendations. And OHCHR also helps states build capacity. That means they're working with governments to help them implement human rights in their domestic system better. So this is what OHCHR does. So what we've talked about so far with the General Assembly, Security Council, Human Rights Council, and OHCHR, these are international bodies. But you should also know there are regional human rights bodies. So a regional human rights body is like a version, these bodies we already talked about on the international level, they can also be on the regional level. And here are the three major ones. There's one for Africa called the African, these are also created by treaties or conventions. So this is the African Convention on Human and People's Rights. This is just for the African region. You can see all the green states are members. This one country here, South Sudan, is not a member. And this is Morocco, not a member. Europe, the European Convention on Human Rights. So these are all the blue countries are members of the European Convention on Human Rights. And in the Americas, the Inter-American Convention on Human Rights. And then all these colored states are members of the Inter-American Commission. America is not a member, but it's actually based out of Washington, D.C. in America, in the United States anyway. And then these treaties also have their own bodies. So like the United Nations has OHCHR as their human rights body and the Human Rights Council. Each one of these conventions has a commission. So there's an African Commission on Human and People Rights, a European Commission on Human Rights, and an Inter-American Commission on Human Rights. So this is like the Secretariat. They administer the treaty. They're the ones doing the reports and investigations. And sometimes they have a court. So Europe actually even has a European Court of Human Rights. So if there's a violation in Europe, it can actually go to the court and they'll decide it like a normal case, except on the regional level. And then sometimes these trials can be legally binding, or sometimes you can have a commission that has hearings and it's not a legally binding decision, but they'll give recommendations. So this is treaty-based regional human rights rules. A court or commission can decide cases. Individuals can bring cases directly to these courts. There's individual complaint procedures. And the strongest of these is the European convention, because the European Convention has a court that has legally binding decisions where the states, if the court decides against them, the state has to follow the court's decision. So that makes the European Convention very strong. So while human rights, I said in the first class that human rights are universal, and that's true. So the regional bodies have the same human rights that we saw at the international level, because like we said, they're universal. But regional bodies can implement human rights and interpret them a little differently. So these regional bodies, they have their own system of state reporting. You know what we said with the Human Rights Council, where states have to report on their meeting their obligations. They have reporting duties, and then the commission can have a fact-finding mission or do monitoring and investigations, and there can be trials. All this happens at the regional level too. So states also have to do reporting at the regional level. These regional bodies can also do monitoring. There can be experts. There's also special rapporteurs at the regional level that will investigate human rights problems and give their own reports and recommendations. So this is in parallel. The international, the UPR, and we're going to talk about treaty bodies in a second, happening on the international level. They're doing these monitoring and reporting. The regional level is doing it. And then it can also happen in domestic law too. So we have multiple layers of monitoring and reports and investigations happening. So in that way, the international human rights system is a bit fragmented. But, and because of that, the obligations may be specialized to regions. So different regions can interpret or apply human rights a little differently to each other. But at the same time, the different bodies can also use the decision of other bodies to develop their own interpretations. So these bodies listen to each other's decisions. So when there's a decision in the European Convention of Human Rights, the African Commission may be reading that, the Human Rights Council and the OHCHR will be reading those decisions, and so international law can be inspired by the decisions in others. It's not legally binding. If you know about law and jurisdiction, of course, the legal binding nature of law is only within the scope. So on the regional level, the European decisions only apply to the European states, not these others, but they have a strong influence, and then their law is going to be influenced by the law developing in this other region. So that's kind of the role of regional human rights. Here's an example of how some regional human rights can be different in across regions. We're going to have a whole class on environment and human rights, but that's so we'll go into a lot more detail then. But for addressing environmental damage as a human rights issue, we can see the European Convention, the African Convention, the Inter-American Convention all treated it a little differently. So in Europe, environmental problems are considered a problem with right to privacy. So this is people inside can't enjoy the land they live on or their homes because of the environmental risk that's happening around them. They cover it under the right to privacy. In the Americas, they actually treat it more as a right to health issue. So when people's health is at risk, they apply it as a right to health issue. And then we see in Africa, they actually have a right to general satisfactory environment favorable to development. In Africa, they actually have a right to a satisfactory environment itself. So, so if you have environmental damage, a person may be able to bring a claim just for the environment not being satisfactory by itself. So you can see, right to privacy, right to health, and a right to environment itself, how these three different bodies treat the environment, how human rights and environment connect a little differently, and their cases will work out differently. Okay. And then you can see these, so the Inter-American Commission also has some special rules. So they've actually had some cases, they have this protocol for a right to live in a healthy environment. A protocol we mentioned last time is a treaty inside a treaty. So this is optional, but states may join this. And they have a special rapporteur, remember that, expert on environmental rights. Okay. Let's talk about Asia. Is there an Asian human rights system? So the short answer is there's not an Asian system. These are the three regional human rights bodies: Africa, Europe, and the Americas. Asia doesn't have a system like that. But there's still regional work happening in Asia on human rights issues. And here's some examples of regional organization on human rights in Asia. So the most important one, the most established one, is in ASEAN, has a human rights declaration. It's not a treaty. These ones are treaties that are legally binding on these states. But for Asia, the ASEAN region, that's for Southeast Asia, for Southeast Asian, Thailand, Cambodia, Myanmar, Laos, Vietnam, they've adopted this human rights declaration, and they have an intergovernmental commission on human rights. Unfortunately, unlike these treaty-based bodies in these other regions, the commission in Southeast Asia doesn't really take serious action because human rights in Southeast Asia is very political. A lot of Southeast Asian countries are committing their own violations, so they find it diplomatically hard to accuse other states of committing violations. But sometimes these institutions can work on certain issues that are not very political. And so, for example, we have the Asian Pacific Forum of National Human Rights Institutions. So national human rights institutions, these are domestic bodies. These are domestic human rights bodies inside, countries like Thailand and Cambodia and Vietnam have their own human rights bodies as part of their domestic government. They have an organization at the regional level, and they do capacity building. They help each other address human rights issues. So one of their major work is preventing torture. In countries like Cambodia and Laos, in the rural areas, police will still commit torture. And the national government also wants to stop this because it's not good for police work to begin with. So these bodies will work on standards to help prevent torture, for example, in the rural areas. Another example is trafficking. Southeast Asia has a problem with sex and labor trafficking of people across borders. This is a cross-border problem. This kind of body will work on helping stop the trafficking problem. And this isn't as political a problem, so it's easier for the state governments. Basically, state governments can cooperate when they're working on human rights issues that the state itself wants to address, like criminal gangs doing trafficking or torture in rural areas. The kind of problems that states can't cooperate on are problems that the government, the military or police are creating itself. It's very political and difficult for states to cooperate to control their own police and military in countries that aren't very strong democracies. Here's some others, Asian Human Rights Commission and Asian Cooperation Dialogue, but these, like the ASEAN, haven't done too much serious work. Okay. There's also UN and intergovernmental bodies. So we mentioned OHCHR and the Human Rights Council, but the UN has actually lots of bodies. UNHCR, this is the UN High Commission for Refugees, so they control refugees. UNICEF is for children. The ILO is the International Labor Organization for labor rights. UN Women is for women's rights. For the Asia region, these offices are based in Bangkok. That's what that stands for. So these are not human rights bodies per se. They work on labor rights and women's issues and children's issues. But they also are involved in human rights issues on their topics. So labor issues also involve labor rights, also human rights. Women's issues also involve women's rights. Children's issues also involve children's rights. So UNICEF is also going to be involved in dealing with children's rights. So these are another source of international bodies that are dealing with human rights issues. And again, these are usually working with states' governments to help building the capacity to help address and solve these human rights problems. And sometimes you can have intergovernmental networks. So that means you can have governments cooperating or doing diplomacy. So just intergovernmental networks. So for example, Japan and Cambodia have a diplomatic relationship. So when Cambodia commits certain violations, here in Asia, in the West, there could be a more confrontational style. But here in Asia, it's much more what we call backdoor diplomacy, where Japan's not going to directly confront a country like Cambodia on their human rights problems, but they're going to have representatives. For example, in the Japan embassy in Cambodia, they'll do quiet diplomacy, where they'll have pressure behind the scenes that'll be quiet, but that's very effective. So for a country like Cambodia, pressure coming from the Japanese government is very influential and very strong because there's a lot of development aid, there's a lot of trade with Japan. So that's one way that also human rights can be dealt with on the regional level, is states, governments actually talking to each other just through diplomatic and channels. And you can see how this is that's very much wrapped up into diplomacy and foreign relations. And then we have private groups, civil society. Civil society and NGOs, non-governmental organizations. This is just groups of private people that create an organization. They can be journalists and academics, or just experts on an issue, and they're also putting together reports, and sometimes these NGOs can be very influential. Their reports, so like big ones like Amnesty International, Human Rights Watch, their reports are very influential, and they can create a lot of pressure on state governments to address the human rights issues. They can collaborate, and they'll do advocacy on issues. And then you can see the distribution of human rights NGOs in the Asia-Pacific region. We see here in Southeast Asia, there's a lot of organization in Southeast Asia. Not as much in our region in Northeast Asia, but some. All right, so now let's talk about, so far we've talked about institutions, standing institutions. That means standing bodies. What I mean is like a group of people created by a treaty. So we have the General Assembly, Security Council, Human Rights Council, Office of the High Commission on Human Rights, and then these regional bodies. So I mentioned in the last class the core human rights treaties. Of course, you have the ICCPR and the ICESCR. We're going to have a special class just on each of these treaties separately. And then we have other human rights treaties on specific issues. So CEDAW is specifically a treaty on women's rights. CRC is a treaty just on children's rights. That stands for Convention on the Rights of the Child. CAD is just for torture. CERD is for racial discrimination. The CMW for migrant rights. CRPD for disability rights. These are all treaties. So these create obligations on states to follow, a set of rules. And in the future, and in the upcoming classes, we're actually going to look at treaties and look at the set of rules that they create and the obligations they create on states. So the main thing that I want to teach now is that each of these treaties also has a treaty body. So, like we said, and each of these treaty bodies has the same monitoring, and they have the same powers as the other other bodies that we mentioned before. So, for example, when we mentioned UPR, a state has there's a 4-year cycle where every 4 years states have to give a report to the Human Rights Council about how they're meeting their obligations. States also have to do that for each one of these treaties. So these diamonds up here are, this is CEDAW. Each one of these is a treaty. These are protocols. These are some extra obligations. And then this is the treaty body. So CEDAW is the Convention on the Elimination of Discrimination Against Women. This is the Treaty for Women's Rights. It has a body, the Commission on the against the Discrimination Against Women. So this commission is like the administrative body. It's the office that administers this treaty. And under this treaty, states also have a monitoring obligation under that. So every year or two, states also have to report about how they're meeting the obligations for this treaty, and they will submit that report to this body. And this body, like we mentioned before, they'll write recommendations. They'll get the report and they'll say, we see you have some shortcomings here. Here are recommendations, and then they'll have a follow-up plan. So this is like a miniature version. The UPR is for every single human rights obligation a state has. That's the Universal Periodical Review for every state, for every human rights obligation. But the monitoring one for CEDAW, it's only for obligations under this treaty. They have monitoring. And of course, these conventions can also do investigations sometimes. They'll do state investigations on specific problems and write reports about that. And usually these extra obligations, these extra protocols, this is a little treaty inside of a treaty. Very often these are for what we call individual complaint mechanisms. So under the original treaty, an individual, if their right is violated, they can't complain directly under the treaty. They can't go to a court if their rights are violated. even if they violate the right under the treaty. But if they follow this, if they adopt one of these protocols are, here you can see individual complaints. So this is the ICCPR. If a state passes this additional protocol, these additional rules, if they adopt that by adopting them in their legislature, like a normal law, then individuals inside this country, whatever country it is, can give a complaint. An individual whose rights was violated, can complain under this mechanism, and that complaint will go to this commission, the Human Rights Committee. The body for the ICCPR is the Human Rights Committee, and this committee will receive the complaint, and then they'll adjudicate it like it's a case. Its decision isn't binding, but they'll give recommendations, and it'll have a very persuasive force. And it's embarrassing for a country to get recommendations and have violations happen. So there's diplomatic pressure created by these reports. So this bottom part is another set of bodies, and we call these treaty bodies. So treaty bodies are administered, of course. This is the Human Rights Commission. So this is the human rights body that deals with the ICCPR and other human rights issues. You can see 1, 2, 3, 4, 5, 6, 7. There's like 20 people here. So that's, between 10, 15, 20 people. That's usually the size of the commission. These are the experts that are writing the reports. For many treaties, they also have what's called MOPs, which is the state members actually come together in meeting of the parties, and they can adopt rules and make decisions about that. So that's the Human Rights Council is a kind of MOP. It's a kind of meeting. It's a kind of council of parties that come together and pass resolutions. And then we have these treaty committees. It's a group of independent experts that monitor. This is made by experts, so these are not state representatives. These are independent experts. So when these treaty bodies write reports, it's not coming from the state. The person acts on their individual behalf, and then states receive the reports on their compliance. And again, like with UPR, NGOs can also give their own shadow reports at the same time, and it will give the states recommendations that are persuasive, but they're not legally binding. These states also give interpretations of the human rights duties. So let's talk about whether the treaty body, whether the decisions are legally binding. Does the state have to follow it? So formally speaking, when a treaty body makes recommendations, it's not binding as a treaty body. The only thing that's binding is the human rights duties. But there's a kind of catch there, which is treaty bodies give official interpretations of a treaty obligation. So we're going to look at treaty text in the future classes, and you can actually see we'll see the text for certain obligations. And in domestic law, of course, courts can give official interpretations, and that interpretation will be legally binding. So these treaty bodies will also give an official interpretation of text in the treaty. And is that legally binding? Well, the catch is the treaty provision itself is legally binding. It's a treaty obligation. So states have a legal duty to follow this text of the treaty because it's legally binding. So if a treaty body gives an official interpretation, that might be binding on the state, not because it's coming from the treaty body, but because that's the official interpretation of the text, and the text is legally binding. So that's an argument people have made to say that the treaty bodies, their decisions actually have a kind of legal status. It can have a binding status because their interpretation of the rules is what the state has to follow if they're going to be in compliance. Okay. So one thing we can have a discussion. I'm gonna open a discussion on the web page, on the Hopi learning management site, and let's compare. I want to compare pros and cons against different kinds of bodies. So for example, what are the pros and cons in the Human Rights Council and OHCHR? So remember, the Human Rights Council is made up of state representatives or officials and, from their home governments coming together and passing resolutions. And I said it's really wrapped up in politics. Whereas OHCHR is independent experts, and they're supposed to be non-political and giving states advice on capacity. What are some of the strengths and weaknesses of these two bodies? This is a question for you, and I'll open it up in the discussion session. What kind of human rights issues do you think the Human Rights Council is really good at solving? And what kind of human rights problems do you think the Human Rights Council might be difficult for it to address? And being a very political body, so it has to be sensitive to international relations and diplomatic pressure among states. And conversely, OHCHR, what kind of human rights problems do you think OHCHR is really good at handling? And what kind of human rights problems do you think OHCHR isn't as good addressing? So remember, and not only the kind of problems, what do you think are the relative strengths? What strengths do the Human Rights Council have in stopping human rights violations? And what kind of weaknesses does the Human Rights Council have to not be able to stop other kinds of human rights violations? And conversely, what are the strengths of OHCHR? Do you think that it can stop human rights violations? And what are some of the weaknesses where OHCHR might not be able to stop these kinds of violations? And then another topic I might add is the difference between an international so we talked about the Human Rights Council and the Office of the High Commission at the international level, and then we mentioned there's also commissions at the regional level, the African, European, and American Convention. Another discussion question I want you to think about is what are the differences between a commission at the international level and a commission at the regional level? What do you think when the Human Rights Council makes a decision or resolution, or the General Assembly at the international level, what kind of issues do you think what kind of human rights problems is that really good at solving? And what are the strengths of having a decision made at the international level? And what are some of the weaknesses? What makes a Human Rights Council decision at the international level not able to stop certain human rights problems, do you think? And conversely, for regional human rights bodies, if this European Convention, the European Convention, if they make a decision that applies only for this region, what are some strengths of that? How can that be, what are some advantages of that in stopping some human rights violations? And then what are some of the limitations to having a regional approach to human rights? So I just want you to think about it on yourself, think about these two questions by yourself, and I'll put in some discussion. I'll put these questions as discussion topics in the forum on the Learning Management site. So if you have some thoughts on it, you can put some of your thoughts in there, and that's the kind of discussion we can have. So that's basically everything I wanted to talk about for this class. From the next class, we're going to, let's open that up. For the next class, we're going to look at civil and political rights. So we're going to look at our first human rights treaty. And even though we're in quarantine and not coming, people are locked up inside, we're still taking off Golden Week. So I'm going to put this material up the week before and sometime before that, but the class is scheduled for May 12th after Golden Week, and we'll look at civil and political rights. So I hope to see you. See you next time. Thank you, everyone. Bye.